All rise. The Court of Appeal in and for the 5th District of the State of Florida is now in session. The Honorable F. Rand Wallace, Judge, presiding. All persons having business before the court draw near, give attention, you will be heard. May God save the United States of America, the state of Florida, and this honorable court. Please be seated.
Good morning. Welcome to an oral argument session of the 5th District Court of Appeal. My name is Rand Wallace. I've been previously introduced. Joining me on the panel to my right and your left is Judge Paige Kilbane, and to my left and your right, Judge Jordan Pratt, both from Duval County. And we have two cases on the docket today. We have the first case up is Opus Condominium Association versus Opus Condominium LP et al. And before we get started, I would just request that anyone who has a device that would make noise, maybe unexpectedly, please mute the device or turn the device off so it doesn't disrupt the attorneys in making the presentation of their cases. And I'm going to assume that the appellant wants 5 minutes in rebuttal unless you tell me differently. And with that, I will invite the appellant to begin.
Good morning, Your Honors. May it please the Court. My name is Samuel Alexander, and I represent the appellant in this case, Opus Condominium Association. The trial court reversibly erred for two reasons, and therefore we request that this court reverse and remand. The first reason is that the trial court erred in holding that a developer owns a construction can satisfy the actual possession by the owner trigger during construction, even though the trigger is intended to mark an end of construction. Instead, the trigger is satisfied only when an owner occupies the construction after construction is completed. The trial court also erred in finding that the appellees met their burden of showing when the contract completion dates occurred, namely before June 5th, 2010. In fact, the appellees failed to introduce any evidence whatsoever of the payment due dates on any of the subcontracts, which they were required to show when the contracts were completed. The general contractor introduced an affidavit that tried to kind of patch this hole in the evidence, but it was legally insufficient because it conflated the completion of the contracted for services with the issuance of the COO. It didn't touch on the contract completion dates for the subcontractors, and it was contradicted by other evidence in the record.
Counsel, can we go back up real quick just to the first point about actual possession? As you described it as occupancy.
Yes.
But I saw a Black's Law dictionary that describes actual possession as occupancy or the power to control, right? So can you unpack that for me a little bit? It seems like, occupancy would be sufficient to establish actual possession, but likewise the power to control, it seems like, would establish. Is it your contention that the developer lacked the power to control?
The developer had power to control, but to understand what actual possession by the owner means in this specific instance, you have to examine the context of the statute. And the context of the statute is to try to determine a date to say when the construction ended. And if the developer can satisfy that because the developer legally controlled the property, that means that the trigger is triggered before the construction even begins. And in fact, if you equate actual possession by the owner with just legal ownership or the right to control, then the phrase actual possession doesn't actually add anything to the analysis or add anything to the statute. So it could just say actually owned by the owner, which is what the trial court's reading and appellee's interpretation provides. So the trigger has to be triggerable in context because it's in a list of whichever comes latest triggers. And so if it's always satisfied, then that means that the legislature inserted a trigger into the statute that could never have any effect. And so we have to assume that that's not what they were intending to do. And the context is important as well because The purpose of the statute is to balance the rights of developers against the rights of people who occupy improvements after those constructions are completed. And in order to do that, they say, okay, developers have to be free from stale claims after a certain period of time. And that period of time starts when a construction is completed. So all of the trigger dates, abandonment of the construction, completion of the contract, actual possession by the owner, or the issuance of a certificate of occupancy, those all should be able to mark the end of construction. And if actual possession by the owner just means legal ownership of the property, and it's always satisfied, and in fact satisfied before construction begins, then it's not a trigger that could ever mark the end of construction. And that reading is supported by the First District Court of Appeals decision in Harrell, which held that in a case where a developer owns a house that it is building, the actual possession by the owner trigger is not satisfied until the developer deeds the home over to what the court in that case called the original owner. And so that court differentiated between the original owner who actually possessed the home and the developer who legally owned the home during its construction.
Mr. Alexander, in this case, the improvement, you use the word improvement, is the entire condominium building. Would you agree?
Yes, that's correct.
Okay. And the certificate of occupancy was issued for the building. Is that correct?
Yes.
So that would include the common areas that would be controlled, I guess the appellee is saying, by the appellee, at least initially when the CO was issued. And you're going to say that once the turnover or the handover provision takes place, it would be controlled by the HOA, correct?
Yes, by the COA. And that also comports with section 718.124, which holds that a statute of limitations for causes of action held by a condominium association does not start to run until turnover of control from the developer to the association. And so we think that the Sable Chase dissent is very informative in this regard. That dissent pointed out that section 95.11 is called limitations on actions, and that statute of limitations contains what are traditionally known as the statutes of limitations, but that statute of limitations also contains what are called the statutes of repose. And they weren't called that in the statute itself, which is to say that the statute of repose as a term is a judicially created term. It wasn't originally in the statutes. And that means that all statutes of repose are within the statutes of limitations, even though not all statutes of limitations are statutes of repose. So, when
At the time of the issuance of the CO, who had control over the property?
the developer,
Okay, and you don't dispute that?
no. But the developer did not actually occupy the property within the meaning of the statute. The purpose of the statute is to, again, give owner occupants sufficient time to discover defects within a property after it's completed and they've occupied it, while protecting developers from stale claims. So if a developer can start the statute of repose running when the developer still owns the property, it doesn't fulfill the purpose of the statute.
Did any of the individual unit owners have control over the common areas of the condo at the time the CO was issued?
No, in fact, and this relates to the second issue, the first unit owner, the property wasn't deeded over until 2011, nearly 2 years after the first COO, or after the COO was issued.
So are you basically saying that in this case, there is a time when this piece of property and the improvement on this piece of property does not have an owner under the statute of repose?
It has an owner under the statute of repose, but the statute of repose doesn't just say the property is owned. It says it's actually possessed by the owner. And
So are you drawing a distinction between actual and constructive ownership?
that's one way to look at it. Constructive ownership is the legal right to possess or control property, whereas, for example, the Aqualog case notes that actual possession is often equated with immediate physical occupancy of the property. And so, again, keeping in mind that the context of the statute is a list of dates that have to be able to come last, that have to be satisfied or unsatisfied to mark an end of construction if it just means owned legally because you have the right to control it, then actual possession doesn't mean anything and the trigger is always satisfied and it can never have any effect
The
whatsoever.
statute doesn't in any way use the word constructive for purposes of describing or differentiating the type of ownership.
It says actual possession by the owner rather than constructive possession by the owner, for example. So we think that that weighs in our favor. The West Park case that both parties have cited, we believe was wrongly decided. It came to the same conclusion at the trial court below, that actual possession by the owner equates to legal control or legal ownership. And again, we note that that results in the same kind of absurd outcomes that this results in. You have a trigger that's satisfied, that's intended to mark the completion of construction, but it's satisfied before construction begins. And in fact, it's always satisfied. You know, a property always has a legal owner. That means there's always someone who has the legal power to possess or control it. So if actual possession by the owner is triggered by legal ownership or the right to possess or control, then the trigger can never be unsatisfied ever.
Can we talk about the statutory amendment history for a second? The statute used to explicitly say that one of the triggers was the date of first actual occupancy or first actual use by the owner.
Yeah.
And the legislature saw fit to amend that language to provide that actual possession is now the trigger. Aren't we normally to presume that the legislature, when it uses different language, it intends and is in fact effectuating a substantive change in the statute? And I mean, you in your brief have supplied us with the legal meaning of actual possession from Black's Law Dictionary, which provides that occupancy is one of two ways to establish possession. So why should we not interpret the later amendment to the statutory text to have affected a substantive change?
Because I think it's a presumption, but I don't think the presumption can withstand the results of its application. So if the legislature intended to change the meaning rather than alter the statute in a way that changed the verbiage of the meaning, then an actual possession really just means the legal right to control. Then that means the legislature intended to create a trigger that can never have any effect. And so I think that if we want to, we have to assume that the legislature did not intend to insert meaningless words into the statute. We have to assume that when they create a list of trigger dates that need to be, they should be triggerable rather than always being triggered. And I think we have to assume that if the intent of the dates is to show when a construction is completed, the trigger date can't always be triggered before construction even starts. So I don't think the presumption withstands those results. So when is actual possession in this case? We maintain that it's in 2013 when the association took over control of the common elements. But even if this court decided that actual possession occurred when the first non-developer owner took over a unit, that occurred in 2011, well within the statute of repose. Moving on to the second issue, the trial court also erred in ruling that appellees met their burden of showing that the contracts were completed before June 5th, 2010. The appellees had to show that all of the contracted for services were completed or what the payment due dates were without regard to when payment was actually made.
And they provided evidence from which a jury could infer that fact. What evidence have you provided from which a jury could infer the opposite?
So I don't think that they provided evidence. I would respectfully disagree that they provided evidence from which a jury could infer that, because there was no evidence at all in the record regarding payment due dates for subcontracts. And they have to show when all of the contracted services were completed, and completion under that statute means when payment was due without regard to when payment was actually made. And there are no contracts in the record. There's no master contract. There's no subcontracts. The general contractor destroyed all of its own records, and none of the subcontractors provided contracts. And in order to kind of overcome this evidentiary deficiency, because we have to remember that it's their burden on an affirmative defense at the statute of repose to prove that all of these contracts were completed before 2010, they had the general contractor provide an affidavit that said, well, the work was completed in July 2009. I was owed payment by April 2009. The work was definitely completed by December 2009 because that's when the COO issued. The problem with the affidavit is the general contractor, to his credit, did not state facts that he didn't know beyond his own remembrance. And I think one of the attorneys below mentioned that the affidavit was kind of cobbled together from the general contract's best memory because he didn't have access to any of his records and there's no subcontracts. So the general contractor never said all of the subcontractors' payments were due before June 5th, 2010. There's no evidence in the record whatsoever regarding when the subcontracts' payments were due. And in fact, the general contractor...
As a follow-up to Judge Pratt's question, though, doesn't that all go to the weight? I mean, his question was, is there any evidence that a jury could attach to fine for the appellee, I believe? Maybe I'm summarizing his question, but the affidavit, and it wasn't just one affidavit, there was more than one affidavit. There was one from the architect as well. Doesn't that all go to the weight? And then when you look at the weight, we've got a preponderance of the evidence here, and we have nothing on your client's side, and we have evidence on the appellee's side.
Because it was their burden on summary judgment to prove their affirmative defense, they had to make a prima facie case that the defense applied before the burden shifted over to Opus. So Opus had no burden to introduce any evidence whatsoever because they never made their initial burden of showing that the contracts were completed before June 5th, 2010, all of the contracts. So yes, there's an affidavit from the engineer, an affidavit from the architect. There's plenty of evidence that a lot of the contracted work was completed before June 5th, 2010. But their burden was to show that all of the contracted for work was completed before 2010. And just because they can't prove their affirmative defense, and they can't, doesn't mean that if this is remanded that Opus is automatically going to win the case. Opus still has to prove its case. They still have their denials. They still have their other affirmative defenses. They destroyed all their own records, and they didn't introduce sufficient evidence to prove their affirmative defense.
And you're in your rebuttal time. You want to reserve?
Yes, please, Your Honor.
Okay.
Thank you.
Morning.
Good morning. My name is David Shelton. I represent Associated Construction Group, the general contractor. At the table with me is Michael Brownlee, who represents one of the subs, Weston Coatings Group. I'll be handling the oral argument for the appellees this morning.
Mr. Shelton, could we pick up where your friend on the other side left off? If you're standing in front of the jury right now, and you're going to point to exhibits A, B, and C as your evidence that all of not only the contractor's work, but the subcontractor's work was completed prior to 2010. What is going to be the evidence that you're going to point to?
Well, let me first say very clearly that what was represented during the reply brief and during the oral argument this morning, that the general contractor has destroyed all their records, is absolutely false. That is not in the record, and that is not true whatsoever. We did maintain an electronic record with respect to this project. That was produced. That's reflected in pages 1046 and 2211-2214 of the record. The electronic file that we produced was acknowledged by the appellant's trial counsel in various parts of the record, including page 1853. So we do have an electronic record. We do have electronic file. We did use some of that file in support of our summary judgment motion. In addition to the affidavit from the general contractor, we had various letters, invoices, those kinds of documents that were in the electronic file were used in support of that. The affidavit also says that the general contractor can testify with respect to the custom and practice that he had with respect to these issues. I'd point out that they never deposed the general contractor with respect to his general practice, his electronic file. None of those issues were developed below, because this is really an issue where they've come up on appeal and they said, we want to get this reversed, so we're going to try to pigeonhole this into the Spring Isle case. We're going to try to say that this is a situation where they had the burden of proof, the only burden of proof. They need to come forward with those contracts. Like I said, we produced some of the documents. We introduced some of the documents from our electronic file. We didn't introduce it all. They didn't introduce any of it. And that's fine. I think they should have, but the fact that they don't doesn't mean that it doesn't exist. So to answer your question, we would produce the remainder of the electronic file. We would introduce that. We would put forward testimony from the general contractor with respect to the custom and practice and how these situations and transactions worked. I mean, it's pretty straightforward that the subcontractor does the work and then sends us an invoice, and then the payment is due afterwards. And the terms of those are pretty standard.
And to put
So
a
we can
finer,
have testimony
right.
to that.
So to put a finer point on my question is, what material from the record as it exists now would you point to if you were to stand before a jury today and ask the jury to infer that the subcontractor work has been completed before 2010?
Well, if we could turn the general contractor's affidavit into testimony and use that, I certainly would point to that, because he says very clearly, he details the chronology of what happened, and there's also corresponding documents in the record, which would be there's a final payment affidavit that's part of the record, page 1740. There's a letter that he prepared dated July 1st of 2009. That's in the record, 1743. There's a certificate of substantial compliance that he prepared that's in the record at 1676. And that basically says that all the work is done, substantially done, so that the owner could make use of the project as intended. So all of that would come in based upon his recollection and his experience with respect to this project. The affidavit clearly says that all the work was done in March of 2009, which is about 9 months before the certificate of occupancy was issued. He says very clearly that all the subs were paid by July 1st of 2009, which is 5 months before the certificate of occupancy. So all of the information that we put forward demonstrates when these contracts were completed, because that's really what the statute is looking at. Is you have a contract, and on one side the performance is the construction of the improvement, and on the other side is the payment. And the affidavits, and you're right, we had the affidavit from my client, we had the affidavit from the engineer, we had the affidavit from the architect, we had the affidavit from sub. All of that said that those key dates, all of the work and all of the payments were made prior to the certificate of occupancy. The defense case was that the certificate of occupancy was the last date. And keep in mind that that's in December of 2009, which is 6 months before they need to have a triggering date in order to have their case be appropriate or proper under the statute of repose.
I think ultimately the appellant's case or position is the best evidence is the contracts. And the best evidence of the payment and the time frame to complete the contract is the contract. Why aren't they right on that?
Well, the problem that I'm having is they didn't make that below. If they had challenged us below, we could have presented different evidence. We could have presented something else from our electronic file. I don't think it's fair for them to get the electronic file from us, litigate the case all the way until we get up on appeal and say, yeah, the contracts would be the best evidence. Why didn't you put those in? When our view is that all of the affidavits, all of the business records that we had proved our case. We had to come forward with a prima facie case that said everything happened by the last trigger date. Our view was the last trigger date was the certificate of occupancy. Everything we said in all the affidavits from all of the contractor, the engineer, the architect, and the sub said the work and the payments were all done before then. Our case was the last date was the certificate of occupancy. And they didn't have any evidence with respect to the subs. They didn't try to introduce anything like that. I mean, these are sophisticated construction defect attorneys who were handling this case at the trial level. They knew what the situation was. They knew I submit that they knew what the electronic file says. They know what the standard subcontract says. That's why they didn't go down that road at the trial court level. They didn't take our deposition. They could have certainly taken the deposition of my client and said, yeah, your affidavit says the payments were made by July 1st. When were they actually due? Because they knew what the process is, what the standard and custom is in this industry. It's not to wait, to have the due date be so far down the road. And that's really the thing that I want to bring to the court's attention is that for them to prevail on this issue, for it to be a genuine issue of material fact, the due date of these contracts has to be 11 months down the road. Because my client says the subs were paid by July 1st. So if you say, well, they weren't due for another 30 days, that only gets them to August. If you say they were due 60 days down the road, that only gets them to September. Even if you say they were due at the time of the COO, 5 months down the road, that only gets them to December. They've got to get from July 1st all the way to June 5th of the following year. They've got to say that if they had these contracts, that they would allow them to get paid 330 days after they did their work. There's just nothing in the record. There's no suggestion. And under the new summary judgment rule, the Florida Supreme Court has said, we don't take trivial arguments anymore. We don't take slightest doubts or metaphysical doubts. I would submit that this is beyond a slightest doubt or a metaphysical doubt, that there would be a contract that the subcontractor would agree to that says, yeah, you're going to do the work in June, but you're not going to get paid until the following June. Because that's really if they don't have that, then they don't have a trigger that makes sense for purposes of their statute of repose, because they've got to have something after June 5th of 2010.
Well, there is the other trigger, and maybe we can pivot to that. So leaving the realm of the factual and the evidentiary, there's the legal contention about actual possession. And as I understand your friend on the other side, his suggestion is that your reading of the statute leaves that potential trigger without any practical effect in any possible case. Could you give us an example of a case under your reading of the statute in which your understanding of actual possession would be able to serve as the trigger, as the latest date for purposes of the statute of repose?
Well, certainly the Herald case that they decided, and they cited to, and we discussed, is a case where that happened. And that was a case where the developer and the general contractor were the same entity, and they sold the completed home, and the court looked at the sale of the completed home and to be the trigger there.
But counsel, isn't that different? That was, the warranty deed was issued, what was it, a week after the COO? So they weren't pinning it on that COO date. They were instead pinning it on the owner themselves. So to Judge Pratt's question, especially in a condo developer case, can you give us that example? Maybe something a little, even if it's not from a case, just a factual scenario.
Well, I would, my view is that the statute applies with respect to all types of improvements, because it says improvements, it doesn't say condos. So we don't have to try to pigeonhole this language into a condo situation in order for it to have some kind of meaning, which is what they're saying. They're saying if it doesn't apply, or if we can't fit it into the condo world, then you should just ignore it. And I think that's improper because the statute says all improvements. And that's what we've got. We've got an improvement to real property. We've got this condo building. I would point out that they keep saying that the problem they're describing to Your Honor is that the developer is always the owner before the construction begins. Before the construction begins, the developer is owner of the land, but the statute of repose doesn't deal with the land. It deals with the improvement. And so you have to look at the improvement being done, and then you have to say, okay, at the time the improvement is done, then look at actual possession. And I would submit that based upon this record, there was actual possession, meaning there was direct physical control by the owner before the certificate of occupancy. As I mentioned before, there's this certificate of substantial compliance, which comes out in March, which says it's basically done and it's fit to be used. And they could have come in and started using it based upon the certificate of substantial compliance at that point. And so in this case, that's why it fits in with the certificate of occupancy being the last trigger here. I can't think of a real world example where this happened, but I would point out that the statute doesn't make any kind of exceptions for condos. The statute of repose doesn't have any language. It doesn't say purchaser, occupants. It doesn't have any of this language that they want to put in there. It doesn't say anything about condos being treated any differently. And certainly the Cope decision that they mention out of the third DCA doesn't stand for that proposition either. Actually, it's quite the contrary. The third DCA said very clearly, and this was 1999, that the turnover statute with respect to the condo statute of limitations doesn't apply because there's a difference between statute of limitations and statutes of repose. And they want to conflate them and suggest that they're the same. But ever since 1999, the third DCA has very clearly said that they're not the same. And no court has disagreed with the third DCA with respect to that point. I would point out that the purpose of the statute of repose is to draw a line in the sand, is to give us some certainty and some predictability with respect to when lawsuits can be brought against the contractors, the architects, the engineers. And in all the cases that we've cited, including the West Park case, they point out that the legislative intent of the statute of repose is to cut off stale claims. And if you buy into what the appellants are arguing, we lose all of that. We lose all of the certainty. We lose all of the predictability because then we just have some open-ended situation because they're saying, well, you got to wait until the last unit is sold, which here is 2014, so you're talking about an additional 4 years. What happens if it goes on forever, the last unit? I mean, there's no predictability or certainty. There's no protection for us, which is the statute was intended to protect us, our side of the equation. There's no certainty and predictability. There's no protection under their argument. And what they're doing is they're trying to change the statutory language with respect to this. Your Honor was correct that initially the statute talked in terms of occupancy and talked in terms of use. And I submit that it makes a big difference when the legislature changes from occupancy and use to possession that they can't then mean the same thing. If they had meant to keep the trigger focused on occupancy, there's no reason for them to have made a change to the statute. So I think West Park got it right. They focused in on who had the right to exercise direct physical control over the improvement. And based upon our record, we very clearly have that. The appellant trial counsel admitted to the trial court that the developer was the owner with possession, was the owner with control, and with those admissions, under that definition, they can't prevail on that first issue. I don't know if the court has any issue or any questions with respect to either of these issues. Anything else that you'd like for me to address?
I don't think so.
Okay, well then, we'd ask for the court to affirm with respect to the statute of repose issues. Thank you.
All right, thank you, Mr. Shelton.
Thank you, Your Honors.
Counsel, could you please address your friend on the other side's argument about whether the statute might have, under his interpretation of the statute, an effect outside the condo type of situation, and whether we should, base our interpretation of the statute on, whether or not that trigger could ever apply, particularly just in the condo context?
So our argument has never been that that the language has a unique application, that their argument only doesn't work in the condo application. Their argument never works. And I think that was made apparent when my friend on the other side was asked to provide an example of when, if actual possession by the owner is the same as legal ownership, under what situation could that ever not be satisfied? Could it ever not be triggered? And there are no examples, because a property always has a legal owner. He couldn't provide a single example. The example that he provided was the Harrell case, but the Harrell case supports our position. The Harrell case said that even though the developer was the legal owner of the improvement, actual possession by the owner didn't happen until the legal owner of the improvement deeded that improvement over into what the court in that case called the, quote, original owner. Because the court understood that in the context of a statute that's trying to mark an end of construction, the person who builds the construction can't be the same person who occupies the construction, unless for some reason someone, builds a house and then moves into it, or someone builds an office building. If a developer builds, an office for their development company and then moves their company into it, then yes, that would start the trigger running. But if legal ownership just is the same as actual possession by the owner, then the word actual possession is completely unnecessary in the statute. And we maintain that the legislature doesn't put meaningless words into statutes, and they don't create triggers that have no effect ever. And it's not just a condo issue, it's in any given case. I'd also dispute that that the general contractor showed that the work was completed in December of 2009. The general contractor said the work was first of all, the general contractor said all the subs work was completed in July of 2009. But the building official said, well, there was still work outstanding in November of 2009. That's why the certificate of occupancy didn't issue until December of 2009. And the general contractor said, well, all the work on the project was completed by December of 2009, as shown by the issuance of the COO. So the general contractor equated the issuance of the COO to the completion of the contract, but those are different triggers. The general contractor didn't say all of the contracted work was completely finished, period, and no work remained outstanding. It said all of the work was completed, as you can tell by the COO, but the COO just means all of the work required to close the permit was finished. There could be lots of work outstanding. And again, it's their burden to show this. This is just an affirmative defense. It's not the meat of the entire case. If they want to get out of having to litigate this case by showing that this very specific circumstance defense applies, they needed to provide these records, or they needed to provide an affidavit that covered all possible scenarios. They could have had the general contractor say all subcontractors' payments were due before June 5th, 2010. They didn't do that. This court should reverse and remand for further proceedings.
Thank you, counsel. Case was well argued, and we'll have a changeover right now. If counsel for the next case could